Before I continue reading from the History of American Constitutional or Common Law, let's take a pause to examine the Constitution itself. In the first video, we see that the authors referred to the Constitution of the United States. That's a clue that they are referring to one of the two constitutions that we have. Whenever you see the Constitution for the United States of America, you know that the writers are referring to our organic Constitution, the one that was created in 1787, adopted in 1789, amended in 1791. This represents our de jure government. According to Black's Law, this is defined as having a de jure form of government of right, legitimate, lawful, by right and just title, by law. And in our first video, we already discussed what law refers to. Whenever you see the Constitution of the United States, those are the bylaws of a corporate government created in the Act of 1871. This happened after the Civil War when our country was bankrupt and needed to secure loans from the European royalty and bankers. And they said, well, if you want our money, you're going to have to create a corporation and give us a controlling interest in that corporation. So this was done to set up a separate government for the District of Columbia. It is a de facto government. In fact, indeed, actually, a state of affairs, but is illegal or illegitimate. It's by equity and not by law, is not constitutional. Thus, an officer, king, or government de facto is in actual possession, but by usurpation and without lawful title. Again, Black's Law Dictionary. In this book, we see the Constitution referred to as the Constitution of the United States. So while I'm going to continue to be true to the actual text of the book, I think it's important for everyone to recognize that they may be unwittingly referring to the Constitution of the de facto government. Much of it is the same, but there have been subtle changes in that document which have a very significant impact on its meaning and application. And we have to ask ourselves, when folks swear an oath to uphold the Constitution, which Constitution are they swearing to uphold? Okay, so let's jump back into Chapter 1. During the past century, the Congress of the United States and the legislatures of the several states, as well as the judges, have presumed to exercise the authority to merge the procedures of law and equity. This is authority they don't have. Yet this, too, is part of the problem we face. When we realize that a court of common law proceeds according to the course of the common law, and that the parties have a right to trial by a common law jury, where the jury exercised the authority to hear and decide questions of both law and fact, we can then know that if we are in a court where the procedures have been merged with equity, then we can know that we are not in a court of common law. In the book, they give an example of the Constitution of the state of Iowa. Article 5, Section 6, it states in part, "The district court shall be a court of law and equity, which shall be distinct and separate jurisdictions." Obviously, they've not been lawfully merged, and we don't have to accept the idea that they have been merged. We must realize that the principles of common law and of equity are those as distinguished and defined in England before the adoption of the Constitution of the United States of America. Any modifications in definition or practice of either law or equity in England since the adoption of the Constitution of the United States of America have no significance, bearing, or authority in the United States, since we are no longer under the jurisdiction of either Parliament or the judges of England. Now, I do have to interject again. As I just showed you, here they're referring to the Constitution of the United States without recognizing that that particular constitution does put us back under the thumb of England, given that it was a corporation handing over certain authority to the bankers and England. I suspect that the authors, when they use the term the Constitution of the United States, really mean to be saying the Constitution for the United States of America. I believe that they are thinking in terms of the organic Constitution versus the bylaws of a corporate government and have simply misspoken. Or it's possible that these authors are unaware of the important technical differences in the way we refer to two different constitutions, where the Constitution of the United States of America or the Constitution of the state of Iowa or of any state mentions law, it means common law. It does not mean any other kind of law. In addition to the above-mentioned jurisdictions of law, meaning common law, and equity, which are the only judicial jurisdictions authorized either by the Constitution of the United States of America or by the Constitution of the state of Iowa or of any state, as drafted in conformance thereto and being second thereto, there is also a private political jurisdiction which is operative only on those who volunteer into its private domain outside of the Constitution. It's known as law merchant, the private rule of the bankers and merchants. Law merchant is neither law nor equity. It's only raw, private political power, alien and illegal to our Constitution whatsoever, and operates outside of the Constitution. Our Declaration of Independence charges that America has been progressively subjected to a jurisdiction foreign to our Constitution, meaning the unwritten English Constitution. This foreign jurisdiction was a jurisdiction of lawless, ad hoc equity out of the Roman civil law under the stark cover of such obscenities as the writ of assistance, which our courts of today also claim to have the authority to issue, which allowed summary plundering of the colonists' wealth and substance to the advantage of the East India Company, which controlled the Parliament, as today it allows the summary plundering of the American citizens' wealth and substance to the advantage of the banks and other financial institutions which control the Congress and state legislatures. These writs, even as only one wrong perpetrated by the commercial interests in the Parliament, were given authority by an equitable jurisdiction called a debt action in assumpsit. This action, which gave satisfaction pursuant to the customs of the law merchant, having been voluntarily entered into, had been an old debt action, triable in a court of common law, merely as a courtesy of the common law courts, and not inherently a part of common law, and triable by a common law jury as a protection to the defendant until Lord Mansfield, Chief Justice of the King's Bench in 1760, arbitrarily and on his own authority, denied trial by jury in debt actions in assumpsit, and he removed that action from the courts of common law into the courts of equity, where a trial by jury could not be had, and where there was merely a summary proceeding with no semblance of a due process of law. This case is known as Moses versus McPherson, and is the case that sparked the American Revolution and caused Thomas Jefferson to say that English law, since that date, should not be used over here. It was this equitable debt action in assumpsit which the Seventh Amendment of the Constitution of the United States was specifically meant to outlaw by specifically providing that in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. The significance of this is pointed up by the fact that any controversy involving money, gold and silver coins, in an amount greater than $20, or any property, such as real estate, can only be tried in a court of common law with the right of trial by jury. This means that any mortgage foreclosure action can be tried only in a court of common law, and that the state legislature has no constitutional authority to provide by statute that mortgage foreclosure actions shall be equity actions. This means that sheriff sales as a result of these equitable mortgage foreclosure actions are null and void, and that the sheriffs have participated in criminal confiscation of real property in violation of the Constitution and of their oaths of office. Now, I'm just going to add a comment of my own. There are many constitutional sheriffs these days who recognize this, so we're not going to lump all of the sheriffs together. And they won't participate in this kind of action. This is why it's so important for us to determine if someone running for sheriff is a constitutional sheriff or not. So it can be seen that summary and arbitrary confiscation of income and property is nothing new in American tradition and history. Out of an illicit, meaning unlawful and unconstitutional, equitable jurisdiction. It's precisely this equitable jurisdiction wherein the chancellor enforces the combination of unconstitutional executive and legislative equity, which is the jurisdiction foreign to our Constitution, referred to in the Declaration of Independence. This is precisely what our American Revolution was all about, and what our Bill of Rights prevents. It's also a measure of the extent that the bankers and their stooges, the lawyers and judges, as well as the politicians of both major political parties, have betrayed the public trust and have attempted to place us in a dictatorship of unelected rulers. I imagine this has given everyone some food for thought, so we'll just stop here and pick it up in the next episode when we get into the role of the sheriff. We'll do some more on the civil law and a definition of the republic.